We are live.
All right, welcome back to the House Judiciary Committee this Thursday afternoon, April 30th, and we're turning our attention to H-193 and activating to a child and parent legal representation working group, looking at this bill to see if it's something that's can be put or should be put into the miscellaneous bill, or if we're going to need to continue to work on it beyond this week, because we're going to be voting out the miscellaneous bill on Friday. So we'll start with a walkthrough of a new draft. So.
Okay,
We'll do that. Thanks.
without further ado, sharing my screen there we are. Before the committee is an amendment to H-193 that may not live in H-193 anymore. That's to be determined. But for the record, Ben Novogratz from the Office of Legislative Counsel. So this is let's say a streamlined version of what H-193 once was. And so with that in mind, I'll just kind of go through it. So this creates a child and parent legal representation task force to study the need and potential viability of an improved legal representation system for children and families who are involved in judicial or administrative proceedings concerning children in need of care or supervision, CHINs, relief from abuse petitions, or substantiations of abuse or neglect. The task force is composed of the Chief Justice of the Vermont Supreme Court, or designee. There's or designee after everything, except for the Executive Director of the Vermont Parent Representation Center. So it'll be the court administrator, designee, commissioner of Department for Children and Families, or designee, the Defender General, child, youth, and family advocate, the executive director of Voices for Vermont's Children, or designee, and the executive director of the Vermont Parent Representation Center. Subsection C outlines the powers and duties, which have been revised to be a little bit more, less prescriptive. The task force shall assess and determine whether reform of Vermont's legal representation for children and families is necessary by exploring the following topics: standards recommended by the ABA, U.S. Children's Bureau, and the study of CHIN's case processing in Vermont, which was authored by the National Center for State Courts and published in May of 2021. To consider compliance with funding and reporting requirements in order for Vermont to leverage funding under Title IV-E of the Social Security Act, identifying the processes and amounts of Title IV-E funds and other funding sources to support any reform system, using an interdisciplinary model of representation, including pay scales, performance measures, supervision and evaluation processes, and recommended caseloads for attorneys, social workers, and other child and family representatives, and then any topics relevant to creating a reformed child and parent representation system. As you can tell, this has not been edited yet. This task force would have the administrative, technical, and legal assistance of the court administrator's office. The report is due on or before December 15th, 2025. Where the task force submits a report that proposes any necessary reforms to the legal representation system for children and families who are involved in CHIN's proceedings, and propose legislation to implement such reforms to the Senate Committees on Judiciary and on Health and Welfare, and the House Committees on Judiciary and on Human Services. Meetings: the Chief Justice or designee calls the first meeting of the task force by August 1st of this year. Majority of the membership shall constitute a quorum. Task force shall meet not more than 6 times. The task force shall cease to exist on February 15th, 2026. I forgot to put in that the Chief Justice would also be the chair of the committee, unless the committee wants them.
Chief Justice or designee?
Or designee would be the chair, unless the committee wants them to pick a chair from amongst themselves once the committee or the task force is formed. No. Representative Christie has let me know.
Just a quick question. I may have missed this. Is there a reason that the report only contains recommendations regarding Chin's proceedings and not relief from abuse petitions or substantiations of abuse or neglect.
I would defer to
Yeah, let's add
Chair
those,
Malone. Okay.
because when I suggested that language yesterday, I neglected those two.
Oh.
That was actually part of the broader scope
Yeah.
of the discussion when we started and strong and discussed.
That was an oversight.
Yeah.
The other thing I just, and before Ian real quick is, I don't think you need to have the task force to meet not more than 6 times because there's not compensation involved in this. So just to flag that. But Ian, thank you.
Those were both of my, if they don't have any proposals for necessary reforms or legislation to implement those reforms, did they not do a report?
We could say that in the report.
And how did you decide it was a task force?
I leave that to Mr. Chris.
Working group versus task
Yeah.
force. I mean, Judge Zoning explained to us.
Judge Zoning explained it once and I didn't really understand, so I guess you can explain.
Well, we'll have Larry Chris, and we have him as a witness, explain that. I'm sure. Any other questions?
So the only other, so just to clarify, remove the limitation on times to meet, add the Chief Justice as the chair. I'm gonna leave it there for now.
No, and add,
Oh,
or
and
maybe.
I added it, that's why it's not in my mind anymore.
It's already done. It's already done.
Yes, Chin's proceedings, relief from abuse petitions and substantiations of abuse or neglect, which is now lines 1 and 2 on page 3.
And when Marshall, I assume Marshall's gonna get here, I'll make sure that I point that change out to him as well. So does somebody else have a question? Yeah, Coach.
Just to comment, what initiated a lot of the discussion, for the bill itself, was the substantiation problem. And, and it just gets to the heart, of, what we're attempting, to, bring to the surface and then hopefully end up with our work ensuing being policies to help mitigate the problems that we've had. That's probably the nicest way to come up with it.
Yeah, that's the intent. And you and Barbara are sponsors of this, of the bill, of this.
Yeah, I know.
So other questions for Ben? Not seeing any, I think we'll go to Judge Zone next, to have him defend his definition of versus working group, so.
We're on.
Thank you for being here.
Thank you. Tom Zonek, Chief Superior Judge. A task force is generally it's typically something that is more temporary, assembled to attack a specific problem or achieve a specific result, whereas a working group is generally recognized as more ongoing, longer term, and broader in scope. I think an example could be if you have a pile of wood, the task force is told, go move that pile of wood from place A to place B. The working group is told, we have a pile of wood. What should we do with it? And
That's a very helpful analogy.
And when you decide what to do with it, you can make a recommendation on how we should do it. And so I think that's the real difference. Here, the legislature is saying, we know we have something we want done. Here's what it is. And so you're going with a task force, but that's a policy decision on how you view that. As before, I did go over this bill. It did make some changes from the initial drafts, as you pointed out. One thing was it adds the court administrator, which I know the Chief Justice thought was a good idea because they will be, Terry or her designee will be providing technical assistance. He did ask previously, and I testified about, he thought it might be helpful to have a trial judge or chief superior judge or designee. Even if that's not in here, I can still be available to consult with the chief or and Terry and the task force as need be. So I'm not saying, please throw me in. If it's helpful, that's fine, but otherwise I'll still be available to participate and assist as may be necessary. And the chief, as before, supports this, and he's willing to undertake the responsibilities of working within it.
Any issues with any of the language or any suggestions?
I think the language is clear. It sets forth what you're looking at. It involves the areas that you've talked about in terms of not just the areas that we deal with in court, but also the administrative proceedings. And it provides a roadmap for the task force to take something from here and move it there.
Any questions for the judge? All right, thank you very much, Judge Zoning.
Have a great day. Take care.
Thank you.
Thank you, Judge.
So why don't we hear from Larry Chris so we can get a counter view of what a task force person.
I'm here.
I kind of like that explanation.
Yeah, you're gonna have to come up with a better analogy.
Yeah, enough feel bad.
Yeah.
Stay on, Judge.
Left already, so. And also testify about the bill itself, not.
I'm Larry Christ. I'm the director of the Vermont Parent Representation Center. First of all, I'd like to say that Judge Sone is absolutely correct in his definition. I apparently misunderstood his definition when he explained it some month and a half, 2 months ago. So I went back, did some research and said, no, it is, exactly as he described.
All right.
And in fact, he described it much better than I could have. I want to thank you for the opportunity to come back and take a look at this bill. I'm going to do something really quick, which is just to outline why and then entertain any questions that you have. The problem. Vermont is not throwing down federal funds from the Children's Bureau to the degree that we can. We just aren't doing that. We could have been doing it for years, but we haven't for a variety of reasons. The major reason is that our planning has been hampered by an absence of authority that can move this process forward. This bill gives us the authority to do that. And the third is that the current general fund expenditures are inadequate to meet the evolved model of how to provide effective legal representation for people. It's not just lawyers, it's lawyers and social workers. It's not just lawyers who meet their clients at the courthouse just before their hearing. It's people who understand their clients, understand the difficulties, the strengths and the weaknesses of their cases, and who can provide both DCF and the court with additional information that typically is missing in these hearings now. The solution, the authorization of a task force under the auspices of the Chief Justice with key people who understand these issues, but with the intent of bringing in the voices of many more people through this process. Because I have never seen a good idea that wasn't made better with more people looking at it, quite frankly. And the current iteration of this bill does in fact identify the model design that incorporates key issues that are being adopted across the country and for which there is a record that shows this system that is being utilized now, that is being underwritten by the federal government, works. It doesn't mean our current system doesn't work at all, but every system we have can be made better. And in this instance, the federal government, in an unusual way, is saying, we will pay you to make it better. And I think, frankly, I would suggest this, and it's been raised by, Matthew Bernstein with me this morning, that I believe the current version calls for the task force to be dissolved, I think in January of 2025, maybe January 15th, I'm not sure the date. Matthew raised the concern that there might be issues that the legislature would identify with the report, that if the task force is not still in place somehow, who would the legislature go for to try to get a unified voice on addressing those issues? So I would raise that.
So you'd want a different time for the task force ceasing to exist?
Right, that's correct. Matthew has suggested another month or 2 months, just so that there is an entity in place for you to call upon.
Okay,
Well, right now it's listed as February
right.
15th.
Okay, I stand corrected for the second time.
You know, we had moved the date this morning
Right.
because it previously was,
January
as you
15th.
say.
Yeah.
But whatever the committee decides will work.
Mr. Green Team suggested May 15th.
Yeah, I mean, I think that's fine. May 15th. Makes sense. Okay, anything else with the current draft? If it is, then we can open some questions.
I think the current draft does what we wanted to see happen, which is to see this issue move forward.
Yeah, Barbara.
So this language says that the task force shall not meet more than 6 times, and I'm wondering,
I suggested we strike that. Right.
okay,
Yeah, because there's not compensation involved.
Right,
So
okay.
that's why it's normally in there.
so then we don't need to add that. Okay, sorry.
Yeah, no.
That before? Okay. I think that was my understanding.
Any other questions for Larry? Yeah, go ahead.
I have a language question and I'm not sure. So I'll ask, your opinion, just, and the, page 1 line 4, the, stating, the purpose, the charge of the task force, to study the need and potential viability of an improved legal representation system. I don't know, for some reason, potential viability is bothering me. I mean, sort of, first of all, it sounds kind of redundant, but maybe not. Anyway, what do you think?
I think that language was there because we want to make sure that this can be paid for. And I think that's where the potential comes in play. Because if it turns out that we don't have a way to draw down the federal money for some reason that, well, then we need that explained.
Yes, so I would suggest, so that might just be viability or potential sustainability.
So where exactly, I'm not.
Page 1 line 4,
Page
It's
one.
not a-
Thank you.
just a language question.
The reason why I phrased it this way is because, one of the concerns that was raised in previous testimony was is this sort of deciding what needs to be done before the group meets and does its work. So phase 1 of what they're doing is this needed? And then if they identify that it's needed, is it potentially viable to? So that was sort of my thought process as far as the language transfer,
Gotcha.
without sort of putting the cart before the horse.
Yeah, I get that part.
It's the word potential.
It's the redundancy, I think. If there's viability, inherent in the term viability is potential.
It's deleted.
Thank God. You're totally right. That's wrong.
I think that's a wise decision.
Yeah. All right, now it can go forward.
Yeah. Okay. Any other questions for Larry? All right, so.
Thank you. I would just like to thank the committee. I know I've been in here many days this session, and quite frankly, it has been educational and instructive, and sometimes incredibly humorous to watch you guys work. It really has been. No, this is the way the system is supposed to work, and I think your discussions I've enjoyed it. So, thank you.
Thank you, Larry. I'm glad somebody.
I feel like I got my tax dollars to work.
All right, so, Marshall, let's hear from
Talk to
you
your
next, if we could.
Yes, absolutely.
It's a parting gift.
And just I want to flag for you, Marshall, that there was, an oversight in the drafting on, if you have the bill on, page 3, I guess that'd be line 1, where it says involved in Chin's proceedings, it should also say in Chin's proceedings, relief from abuse petitions or substantiations of abuse or neglect. Those other 2 phrases were inadvertently left out. My fault.
So we reviewed the new bill. We continue to have some serious concerns with it. In particular, our concern is that this bill is essentially chasing a process that's already started and will essentially slow down a process that's already started. So I want to focus, this bill focuses on a couple of key issues. In particular, the availability of Title IV funds. Our office is already pursuing Title IV funds. We're pursuing those matching funds, and we are actually pretty far down that line. We are at the point we've been meeting with DCF. We understand the state's limitations in terms of DCF's ability, given its outdated IT system, to do certain types of reporting and compliance that would be necessary to collect the Title IV funds. We found an outside organization, private company that can provide that reporting and compliance data with the feds. And we're basically at the point of signing a contract with them to start doing the work of submitting 40 requests and working out a memorandum of understanding with the Department for Children and Families, which has already largely been done. We did that in the first phase of this work. But it's actually part of the benefit of working with this private company is they've been working with jurisdictions all around the country. So they're very familiar with what it takes to get your MOU approved by the federal AHS, which is sort of that's the threshold step that you have to take to start receiving those 4E funds. And they were able to give us a lot of input as to what's been accepted around the country, what's been rejected, and sort of how to tweak our original MOU in a way that makes it pretty much a deadlock that federal AHS will accept it. So we're already that far down this process. Like we are anticipating that this summer, once the legislative session wraps up and we've got more time to focus on that stuff, that we will be working pretty much full steam on the 4E funding stream. And from everything that we've heard, we would not anticipate that taking very long. Once we get the contract signed and in place, it's certainly within this partner organization's interests to start things moving as quickly as possible, because that starts them getting paid as quickly as possible. So we'd anticipate that 4E funds is something that we are going to have worked out very quickly. And we already even have, I didn't think that we would at this stage of the process have any sort of guidance as far as what the 4E expenditure plan would look like. But it turns out in talking to our other partners that there's really actually been federal AHS has been approving kind of a very specific set of goals for every state. So every jurisdiction, even though the feds are sort of giving jurisdictions the freedom and saying, hey, come up with a plan. Like, how would you like to spend these funds? They're actually approving the same sort of 3 goals all across the country. And so really what we're looking at is that we would be looking at drawing down 4E funds first to bolster our recruitment, retention, and training. And there's actually reasons to do that first, and that's because you get a higher 4E match for your recruitment, retention, and training than you do for your general expenditures. And the way that 4E funds work, it's not a federal grant, it's a federal entitlement. It's actually part of the Social Security Act. And it means that when you spend money, 4E money, it rolls over on top of itself. So if you spend some 4E money one year, that's built into your base 4E calculation for the next year, and you can build on that. And so they suggest that we start out by identifying training and recruitment as our number one, because it's got the highest rate of reimbursement and therefore allows us to sort of roll the money in faster and start increasing our reimbursements at a faster rate. The second thing is expanding our interdisciplinary model of representation. Our office has been doing interdisciplinary representation for about a decade since we started our family support worker project, and that's really grown. And I'd say at this point, the interdisciplinary aspects of our work really go down two different paths. We have what I consider our legal partners, and then what I consider our non-legal partners. So, for example, with our legal partners, we have a partnership. We work closely with Vermont Legal Aid because they've got education lawyers, and we don't have education lawyers, but education is often a really significant part of a child welfare case. So we have worked out with them that their education lawyers will work with our clients when we need our clients to have education representation, and that's not our area of specialty. We do the same thing with Disability Rights Vermont. They have special legal standing as a federal protection and advocacy organization that gives them statutory standing. So we use them a lot for disabilities issues we have because they just have better legal mechanisms than we have in order to deal with issues of disability. Then when it comes to, sort of outside of that, we also partner with a lot of other, what I would call social services organizations. So, for example, we work a lot with Adaptive Parenting Solutions, which some people might know. It used to be called Sage Haven. They've changed their name, I think, just to more accurately reflect what they do. That's a private organization that works around parents with disabilities and essentially designing and providing programming and support for parents with disabilities to be able to continue parenting. We work extensively with Therapeutics Works, which does case management for us when that case management exceeds what our family support workers can do. They have a sort of much more advanced level of case management at Therapeutic Works and a lot of resources that they can pull in that go beyond what we can do with our family support workers alone. We work with AALV and the Vermont Afghan Alliance in particular, when we're working with families of new Americans. We rely on them pretty extensively because they have some cultural competencies that our attorneys don't necessarily have. And so really, we've never been just a child welfare defense program, at least since I've been doing this work. We've always been interdisciplinary, and the ways that we've been interdisciplinary have really been expanding since I started doing this work. When I did this work at the beginning, we had the partnership with Vermont Legal Aid for educational representation, and that was about it. Everything else has developed in the past 15 years, and we continue to develop further. We are very hopeful, in fact, so that's, the number 2 priority for our Title IV refunds is going to be to expand our interdisciplinary practice. And so what that really means for us is expanding the use of our family support workers. So we have some embedded in offices. We have others that are ad hoc and can be accessed by any of our attorneys or by attorneys who don't work for us. It's under the Public Defender Act. We provide services, legal support services for anyone who is representing an indigent client, whether they are a public defender or not. And all those services, family support workers, the legal aid partnership, the work that we do with AALV and the Vermont Afghan Alliance, all of that's available not just to our attorneys, but to any attorneys through our office. The third thing that we would be spending that money on, and this may eventually require some changes to statute, is pre-petition representation. And that's the idea that of identifying families early before the point of DCF involvement and getting them connected with legal representation prior to the point of DCF intervention. And this is something that's been sort of toyed around with in Vermont quite a bit. There's been medical legal partnerships I'm trying to remember the name of it. There was one that started out in Lamoille County, spread to Chittenden County. that really works with doctors' offices as the point of contact, essentially saying, you know what, pediatricians are going to have contact with families that are in a state of stress or crisis probably before DCF does. And that's really a great angle, is let's connect people with services and including legal services at that point. We're really interested in developing that much further. That program started out in Morrisville, spread to Chittenden County, hasn't developed much since then, but we think that it's actually a really important part of representation, and the feds obviously do also, because they've been channeling a lot of that 4E money into those programs. And we think that the approach that Vermont's taken in the past, where we start with the medical community as our point of, as a point of intercept before the Department of Children and Families point of intercept, is really a great approach. And that's another thing that we would be intending to do with that 4E money once we get it. Our concern about this bill when it comes to the 4E money is that this bill proposes to create a committee to essentially oversee among other things, the question of, should the state of Vermont collect this 4E money? And if so, how? And if so, in what way? And my point is, we're already well down that road. We've already gone through, we are now at the point where what it takes for us to collect 4E money is signing a contract with an outside provider that we've been working with. And at this point, the process is now out of my hands and into the hands of people who handle contracting. And they have to approve that contract before we can sign it. But we don't anticipate that being any problem. And then for that organization to work with DCF to finalize a memorandum of understanding, and then for that to be approved by the federal AHS. And at that point, we would be able to start making 4E claims and implementing this sort of three-prong approach to spending that 4E money. If there's a bill passed that creates a committee to oversee the process of getting and working with the feds around 4E money, I'm not sure what that means. Does that mean that our office should stop what it's doing because there's now a plan for a committee to be taking on the 4E project? In which case that would be disappointing to us for a few reasons. One is that we've already done a lot of work on this. Second is, I work with a lot of committees, and I don't mean this in any way to be disparaging to the legislature, which creates a lot of committees, but committees are great for policy work. They're not good for getting stuff done work. And we're past the policy stage of this. We're into the getting stuff done phase. And that's not, committees don't get things done faster than we get things done when we are simply working as an organization with a goal. And the moment that we have a committee and we have to talk about, okay, let's go back to the beginning of this 4E process. What exactly do we want to do? What are our goals? And now we want to have the input from the judiciary, from DCF, from everybody about how the defense handles defense practice. And that really gets to a second sort of point of all of this, which is that this committee really, the proposal here really sort of shakes up a lot of institutional norms. We talk about having an independent judiciary and how important that is, nationally, locally, at every level. The independence of the judiciary is important. But within that, when we talk about the independence of the judiciary, one of the things we don't often talk about is the independence of systems within the judiciary. And this bill, by proposing to have a committee to sort of look at, even though, I haven't seen an identified problem with parent and child representation sort of listed in this bill. Like, here's what the problem is, here's what this bill would be intended to solve. And yet this would create a committee to sort of reimagine all of juvenile defense. Now, if you compare that to how does the rest of the justice system work, judges work in a state of, our entire system is structured to work in a state of independence with checks and balances along the way. So, For example, our judges work totally independently, except for their retention process. So once every 6 years, they come before the legislature, and the legislature essentially checks their work and says, we're going to give you the rubber stamp to keep working independently for another 6 years. We do the same thing with prosecutors. Prosecutors get elected every 4 years. Every 4 years, no matter what prosecutors are doing, the voting public has the chance to step in and say, keep doing what you're doing for another 4 years, or we want to change. And it's the same in our system. We have the Defender General, Matt Valerio, has one of the few positions in state government that is independent. Once he's appointed, he doesn't serve at the pleasure of the governor. He can't be removed. But he is appointed by the governor and confirmed by the Senate every 4 years. And in the past, that has been essentially the stamp of, yes, we approve of what you're doing, and go on and keep doing your work for another 4 years. And all of these sort of players in our system are given independence. And this bill would be saying, no, when it comes to juvenile representation, we actually want the judiciary and DCF and other players in the system to have input and into how the defense is doing its job. We don't want the defense to have independence in this area. And to me, that is contrary to a real lot of the principles of law that have existed since the Magna Carta, really, in terms of how the different sections of the judicial system should function with independence. And honestly, if we were in here talking about taking independence away from prosecutors and that maybe prosecutors shouldn't be prosecuting, we shouldn't give them the choice to prosecute the cases that they were taking. Or if we're in here talking about judges, in a lot of states, they have specific juvenile court judges who are trained in juvenile law, and that's all they do. In Vermont, we've always had generalist judges. And I don't think there's ever been a proposal since I've been around to change that. We've always given the judiciary the independence to set up their structure the way they want to. If they wanted to, in fact, they just recently did change and say, we want to have one judge in the state that's specifically a juvenile judge. That wasn't because of some committee overseeing the judiciary. That wasn't because of legislative input. That was because the judiciary decided, you know what, it would make sense for us to have one person who travels around and does termination of parental rights hearings. And so we have Judge Kalpas serving as Vermont's first sort of specialized juvenile court judge. And that's left up to the judiciary to sort out how that works. My concern is we're taking that away from the Defender General's office. We're saying that the rest of the system can work independently, but the Defender General's office, we want to have oversight. We want DCF to have an opinion about what the Defender General's office should do. We want the Chief Justice to have an opinion about what the Defender General's office should do. We want the legislature to weigh in on what the Defender General's office should do. And frankly, from our perspective, that puts us, it's treating us in a way that's really differentiated from the way we treat the other players in the system, from the way we treat the prosecutors, the attorney generals, and the judiciary, who all operate in a world of independent legal practice. And it also, from my perspective, really, the best people at defense are defense attorneys. And when it comes to this sort of level of granular oversight, I don't think it's appropriate for non-defense attorneys to be weighing in on how defense attorneys should be operating any more than it would be appropriate for me to come in and say, I think we should have a committee of, primarily non-prosecutors that should advise the prosecutors on what they should be doing and how they should be prosecuting. Or I think we should have a committee of primarily non-judges to come in and say what we think should be different about what judges are doing or how judges are operating. And we don't do that. We give them independence. We certainly argue with them and we litigate issues with them and we take issues up to the Supreme Court when we disagree over the law, but we leave their internal structure to that. And that's part of my concern here is that the committee that's proposed here would be a committee of people who largely are not people who are doing defense work, and many of whom don't even know what's involved in defense work and what defense attorneys do in their practice. And to have them be guiding what defense work looks like will honestly have the potential to be dragging us backwards. In part, not because anybody has any sort of bad intentions. I agree with the intentions that are sort of outlined in this bill, sort of focusing on Title IV funds and interdisciplinary representation. It's just that we're already 7 steps further along that process than this bill imagines that we are. And if anything happens, this bill is just going to drag us back in that process.
Before I go to Barbara and the other questions, just a fundamental question, which maybe I should know the answer to, but so where in legislation is the Defender General given the statutory authority for this representation of parents in Chin's cases, relief from abuse?
So we don't,
or
just to
substantial.
be clear, and I think that's probably where there's some confusion happening. We don't provide representation and relief from abuse cases. Title IV money is not available for representation and relief from abuse case proceedings. I think it probably should be, but it's not. So relief from abuse, I was actually really curious why that was listed in here. It doesn't fit in with the other stuff. DCF is not a party in relief from abuse petitions. Nothing about relief from abuse fits in with the rest of what's in this bill. So
Families and juveniles or might need representation, but other than that, I understand what you're saying. So how about substantiation and how about Chin's cases? Where's the statutory authority? Because I'm just trying to understand, is this your exclusive, this is Defender General's?
yes, it's in the public, so I don't have the statutory site offhand, but in the public defenders authorizing statutes, there's a provision. I think it's titled something like,
You got it.
I think it's titled something like other proceedings or something, because there's a primary provision that says you get a public defender if you're charged with a criminal offense with a potential penalty of more than $1,000 or 1 year. And then there's another provision, I think it's called other proceedings, that says that you're entitled to a public defender. And this is a weird thing. In statute, it says if the interests of justice require it or something to that effect. In a juvenile case, the Supreme Court, we challenged that at one point because there was a judge who refused to appoint counsel for a parent in a particular proceeding within a Chin's case. It was a case that had already ended, and the parent wanted to file what they call a Rule 60, which is a civil remedy to essentially try to revisit a decision made by the juvenile court. And the judge tried to tell the person, I'm not going to give you an attorney for that. And we challenged that at the Vermont Supreme Court. And we got the Vermont Supreme Court to say, despite the statute, which says only when it's in the interest of justice or only when it's necessary or something like that, because it's practically in every single case, judges do assign counsel for attorneys. They don't actually have the freedom to not assign counsel or to not assign attorneys to parents in child welfare cases. So even though the statute seems to allow judges to not assign counsel to parents in child welfare cases, they're actually required to by case.
So I mean, I think that this is an important point, that if you're arguing that this is our exclusive realm, I need to understand what the basis of that is so I can agree to that.
It isn't, I shouldn't say exclusive in the sense that nobody else is allowed to practice in this area of law. It's just very rare for people to hire private counsel in a child welfare case. It certainly happens. I've had it happen several times during my career. And there's been some great private counsel that I've worked with who have practiced in the child welfare world. But, you know, I could count on one hand the number of individual attorneys who were not either assigned by the court ad hoc, public defenders, or conflict contractors.
So in practice, the Defender General's office is doing most of the work.
In fact, even when it's an ad hoc assignment, which is technically not supposed to be our office's responsibility, the court, I would say, I don't know how much of the time, because I can't say how many times they assign someone ad hoc without calling us. They call us an awful lot of the time to say, hey, we can't find anybody ad hoc. Can you find somebody for us? So honestly, even in the cases that are supposed to be court assignments, we're actually assisting and finding counsel in those cases because the court often has trouble.
Barbara and then Angela. Did you have?
Yeah, just the
Citation.
statute is, it's in Title 13, particular proceedings, section 5232.
Okay, thank you.
And just, well, since we're talking about that chapter, just to mention another statute that's in there that I think is important is, the idea of the Defender General being independent was baked into the system from the very beginning, from 1972, when the Defender General statutes were first written. So we also have a statute, I'm not going to remember, I want to say 5232 or 5332, some variation on 232, somewhere, some combination of those numbers. Very clear in there that the Defender General's office is the only one to supervise or oversee the work of the defense law. And that is consistent with the independence that's also afforded to prosecutors and to the judiciary. And so it's just another reason why we think it's important that independence from our perspective is what allows us to do our jobs. We couldn't do the jobs that we do if we were not working independently. And honestly, I would not expect judges to be able to do the jobs they do if they weren't working independently. And I wouldn't expect prosecutors to be able to do the jobs they do if they weren't working independently. And frankly, even though DCF is honestly the least independent of us, because out of all of us, they're the only ones that serve at the pleasure of the governor. I think that DCF has historically been afforded the independence to work independently, still is given that independence, and that independence is critical to DCF being able to do the job that they do. We don't have a lot of, these are, when we have concerns about what DCF did or didn't do in a case, we sort that out in court. We don't have oversight committees and things like that where our office is coming in and saying, DCF, here's what you should be doing. We think you should do this differently. If we think they should be doing something differently, we say so in court. And that's not because that couldn't happen. In fact, one of the things that I deal with as chief juvenile defender a lot are my attorneys calling me because I've made clear that our attorneys should not be, picking fights with DCF about their systemic practice. And I get calls all the time from our attorneys saying, hey, can you call DCF and tell them they need to stop doing blah, 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 or start doing blah, blah, blah? Or they'll do that with me with prosecutors. Can you call this prosecutor's office and tell them they need to do this and they can't be doing this? And I always say, no. If you want to work for DCF, go work for DCF. They're usually hiring. Same for the prosecutors. Like, we don't step on their toes and they don't step on our toes. They choose how to be a child welfare agency. When we agree with what they're doing, we cooperate. When we disagree with what they're doing, we litigate. Same with the judiciary, same with the prosecutors. We let them do what they do. And when we have a concern about it, we raise that concern through the system that is set up to address those concerns. And and that's how they raise concerns with us too. And so part of my problem here is this really does feel like it's treading on an area that we've had independence in, and where that independence has been successful and it's allowed us to work quickly and it's allowed us to innovate. And it would really hamstring us in a way that other sort of players in the same system are not hamstrung, to have an oversight body that is made up of people who are not us overseeing our work.
Barbara, and then
So Marshall, I'm sorry that you're sort of viewing this in the way that you are. As legislators, it feels like we do have the role to look at policy and figure out if something isn't working. And I think one thing that's been apparent with having the Office of the Child Advocate and also several of us legislators who have been hearing about the system isn't working as well as it could. And so you talked a lot about the things that you are doing, but some of the stakeholders that are listed here don't sound like they're ones that you've worked with. And so my concern is that it's not just a question of like, whose role is it? But we don't have standards for representation in our state. And we don't have consistent training. I understand that
I need
contractors.
to interrupt because I just want to be clear about how inaccurate that is. So to begin with, when it comes to standards, there's been a lot of talk as if there is some problem with standards in Vermont. There are only two sets of standards for attorneys representing parents and children. The ABA has one set of standards and the NACC has another. They are almost identical to each other. They differ on one very granular detail, which is, and this is way in the weeds, but just so that people know, it's for attorneys representing children. How do they handle a situation in which the child's expressed interests differ from the child's best interests? That's the only point of difference in these two standards for attorneys representing parents and children. Our office chooses to teach the ABA standard. We think that that's most applicable to Vermont because on the one area where there's a distinction between the two standards, I think that because Vermont is a state where we have guardians ad litem and attorneys, that the ABA approach is more appropriate to our system than the NACC approach. The idea that there are no standards is 100% incorrect. We teach to the ABA standards.
Okay.
We selected those of the two standards. We selected those because we think it's more appropriate. And we never actually heard anybody say to us, we think you should have selected the other standard. We have a problem
So
with the
I
ABA
understand
standards.
that you use a lot of contracted employees and they turn over a lot. And
We actually have very little turnover on the juvenile side of our contracted employees. We've had high.
So Marshall, let Barbara finish her
Sorry, I
question.
apologize.
So my concern is hearing from stakeholders is really important. There are parents that don't feel like they are as served as well as they could be. I don't know what kind of statistics you keep on hearing or what efforts you make, but this task force or work group or whatever, task force, not only was looking at how to get the funding, but I think it's equally important how the funding is spent. And I think given that we have, like, we do have an office of child advocate, we do, we've heard from other statewide children's advocacy groups. And not everybody is like, yes, this is working as well as possible. So we need to, for the sake of kids and families, be extra. I feel like we need to be extra vigilant because one, they don't have a lobby and they don't have people, like it's just when we hear from constituents or other ways that we get this information. So we should all, like, I feel like I don't see the harm in having a group that's looking, that you'd be part of, that's looking at how to make it better. No one is saying things are going to be taken away. Like, who knows what would come out of it? But I feel like that what I'm hearing is you talking about all the things you're doing. And I know your office works really hard and does great work, but we can do better for kids and families. And I feel like this would give us the opportunity to do that and to have that kind of input that unfortunately isn't built into the work right now.
So just to respond to that, so to begin with, we don't have a lot of turnover in our juvenile contractors. We've had high turnover in our criminal contractors in the last few years. The pandemic's had a lot to do with that. We had a lot of contractors who, as returned to in-person practice, sort of decided to step down. We've dealt with that, but we have not had as high turnover on the juvenile side. In fact, honestly, probably most of the turnover we've had on the juvenile side has been caused by our own system because we've taken a few contractors and hired them into staff positions and then had to replace their contracted position because we hired him into a staff position. In terms of statistics, we do keep statistics. I don't have them prepared for you today, but I could come back as soon as it would take me probably 2 hours to go through my Excel spreadsheet. I'm the person who handles all complaints in our office about criminal attorneys, juvenile attorneys, whether they are contractors or public defenders, whether those complaints are coming from clients, whether they're coming from clients' families, whether they're coming from judges, whether they're coming from opposing counsel, whether they're coming from outside agencies like DCF. I handle the complaints. I can tell you we get far fewer complaints about the juvenile attorneys than we do about the criminal attorneys. I could put that in terms of complaints per case. I could put it in terms of
Is there
complaint per
an easy
lawyer.
way, do people get information on how they can make a complaint? Because
Yes.
understanding is
So we have
it's not been easy for people
have
to do that.
pamphlets that I don't know how well they get distributed, but we distribute them to the courthouses. They have our phone numbers. They also have the phone numbers for the
So,
office,
you know what, like, I feel like we're getting into, like,
the PRB.
I think the bigger picture is you think things are working well and
Yeah.
you've got it.
Yeah.
And
I wanted to keep answering the question because part of your question, you were also saying, you were sort of implying that I'm saying things are going great. I don't think things are going great. I think we have a system that has a lot of problems in it. Weirdly, we do in Vermont, we have more removals and more terminations of parental rights than most other states in the country. And when you look at that, there's actually correlative data that you should be able to see. So when you look at other states that have high rates of removal, high rates of termination of parental rights, you also see low rates of parental educational attainment, high rates of child poverty, low rates of child health care access. Those are like the three key correlating factors to high rates of removal and high rates of termination of parental rights. Weirdly, all those other states that are in that high ranking of removals and terminations of parental rights, they're also high in those correlated factors. At the bottom of the list on almost all of those correlated factors. We have the second lowest rate of children who don't have access to health care. We're in the bottom 10 in terms of children in poverty. And we have the second highest rate, I think it was, of parental educational attainment in the country. So there is something very strange going on in Vermont in terms of decisions to remove and terminate parental rights and how those are being made in Vermont and why we're such an outlier compared to our peer states. And when I say our peer states, what I mean by that are states that are sort of similar to us in terms of their demographics, their economics, their rural versus urban geography, and population distribution. Those are the states that we want to look at, whether they're states that are near us or states that are far away from us. We want to be looking at states that are similar to us and seeing what are their rates of removal and why are we an outlier. I think we definitely have a lot of problems in our child welfare system. I do not think that it is a great system. I do not think that it is a wonderful system in any way. I think it is a system that requires and has a lot of ongoing work in it. I think one thing I've been saying years in this room, in the Senate, and in every room I've ever been given the chance to say it, is that we are long overdue for a rewrite of our CHIMS chapter. It was rewritten last in 2007, went into effect in 2009, but the writing actually took place in 2007. And it really has not been tinkered with since then in any substantive way, except for the small changes that were made in 2015. It is time for a rewrite of in particular, Chapter 53.
maybe it is, but it does seem like it's also really important to look at what we can do to improve child and parent legal representation. And, you know, I would say the same thing about other parts of our criminal justice system. It's not just picking on.
But that's what we're picking on. We're not in here. There's been no bill to propose a commission to look at how are the judges doing.
You know what? Maybe that will come. But we do have an Office of Child Advocate, which is pretty new. And I feel like their independence and ability to also help us see things is part of the tools that we as the legislature need to see where we should be digging and prying. And it sounds like we're just not going to agree on it, but I'm sorry to have you not feel like this is an exciting, good thing.
What I'm disappointed by is the fact that it's based on so much incorrect information. I mean, even in the sort of the way that you're phrasing the questions to me, it's repeating information that was incorrect, which, I put up slides last time showing exactly that we have data to show that this is not what's happening. And it's still being repeated back in the form of these questions. So to me, it does seem like this is in fact that we're picking on the Office of the Defender General and juvenile representation. Because that is what we're doing. It's not anything other than that.
I think, well, I would phrase it, I would frame it differently because I hear a lot of defensiveness in your testimony. And so in case it's informational, I'll share just as one person, one member of this committee where I am coming from and how I see this issue, not at all as an issue of in any way trying to critique or denigrate the work of the Defender General's office. That's nowhere in my mind. And the what I think is great about this is that what you're describing as a necessary independence, which I hear there is a need for a level of independence, certainly. We also tend to work, very in silos, very much and I don't think that benefits the people of Vermont, and in this case, children and families who find themselves in these challenging positions. So to me, that's where I'm coming from. That's how I look at this, that it's an opportunity to bring folks together. Certainly the Defender General's office with an immense amount of experience and knowledge and necessary the foundation, and then these other entities that interact with the Defender General's office to look at this question.
It's just to respond to a question with a question. My question would be, where do you see the problem being that silos within the process of juvenile and parent representation are causing problems? And I ask that in all honesty, because when I started this work, we had a lot of siloed information, and it was not just me, but a lot of people right when I was starting, we were picking up on that as a problem. And that's a lot of what I described in terms of our relationships with legal aid, our relationships with AALV, our relationships with Vermont Afghan Alliance, our relationships with what used to be Sage Haven, and now I've forgotten, I told you what they're, I keep thinking of them, and my name is Sage Haven. Our relationships with Disability Rights Vermont, these all grew up in that time because one of the things that not just our office, but really the whole child welfare system was tackling around the time that I came into this was, how do we break down these silos? And so my perspective on this is, I agree to the extent that we have problems with essentially siloed information. I do want to address that, but from my perspective, that was a problem 15 years ago, and we attacked it pretty head on then. And if there's more work to be done around that, I'm happy to do it, but I don't think it needs a committee. We actually have a committed group of people who have been breaking down those silos all over the place. And if we missed one or two, we're happy to go back and get them. It's
Yeah, that's great. And I guess I'd wonder, would we be here if there weren't people who felt that there were still those silos?
And I think a lot of it is there's people who don't actually understand. I think there's a lot of people who have ideas about what's happening in juvenile court and in juvenile representation, who don't know what's happening in juvenile court and juvenile representation. It's because it's a very opaque system.
Are any of those people on our list of the membership in the task force?
Well, I'm not going to speculate as to how much various people on the task force know or don't know. I think that would be speculation on my part and probably offensive if I said it.
Well, I'm asking
speculative.
because, right, and I'm asking because it's seems to me that they wouldn't be on the task force if they felt like their voices, they had this like excellent working relationship and everything they needed to say has been said, and it just doesn't make sense.
And what I would think is that if that was a problem, we would have heard about it. We would have had a phone call to our office to say, hey, nobody talks to us about such and such. We want to talk about such and such, and nobody's willing to do it. And honestly, that's where I take the most offense of this bill, is because this is all stuff. I've been begging people to talk about this stuff for a long time. Type 4E has been something like, when I went through my emails and just searched for 4E to see like, how many people have I reached out to about 4E in the past since 2018 when it first started? I mean, I was reaching out to Jerry Milner when he was the head of the Children's Bureau in Washington, D.C., right after it was announced in 2018. I was working directly with him. I've been working with the NACC since then, working with TCF in that same time frame. This is all stuff that has been going on. The way that this is written, it imagines a system like it was 8 years ago. It imagines the system as it was in 2018. And this is going to drag us back. This is saying, hold on, let's get a committee together and start looking at interdisciplinary representation. Let's get a committee together and start looking at 4E. We're already way down the track on that. Honestly, if this bill passed, I would be in a panic about, because we're looking at signing a contract with a private 4E consultant this month. Like, that might happen as very quickly. Right now, all of a sudden, I'm looking at this saying, if this bill passes, what does that mean for our ability to try to start working on this 4E stuff? This bill, I think, is chasing something that the actual system is 8 years ahead of.
It's very interesting that to hear you say that, because then I guess I don't understand how are we here? And that's where I'm left like wondering. Obviously, someone feels like that is not the case. So, and I'm not out. Of course, I'm not asking you to identify who those people or.
But I can't sure, because it's not the nature of juvenile law. There's always going to be people who are upset about the outcome of a juvenile court case. It is one of the tragedies of the system. We are dealing in a lot of cases not with, did somebody do something right or wrong or anything like that. We're dealing with the response to tragedy. We're dealing with, how does the state of Vermont respond to a horrible, tragic situation that has occurred within a family? And there's not going to be, like, no part of the outcome makes anybody feel great. Because at the end of the day, a lot of times we are essentially sort of coming in after, we've had communities and families that have really failed and fallen apart. And we are not in a place to put things back together or fix things. We're in a place to try to make the best out of the damage that's already been done. And what that means is we have a lot of cases where a lot of people go home really upset about the outcome. And I've been on every side of that because I've represented children in cases where I've really wanted that child to have their parental rights terminated and be adopted by a really loving, supportive family that will be able to care for them. I've had cases where I'm representing children, and what I want is for that child to be reunified with their family, because I think their family really has something worth building off of and can be put back together. I've represented parents who agree that their parental rights should be terminated and their child should be adopted to another family. And I've worked with parents who very much oppose that. But at the end of the day, in every one of these cases, it almost always ends up with somebody ending up really sad and upset. And so there's no doubt that there will always be people who are upset and unhappy with the system. And honestly, I am very invested in my cases. I'm very invested in my clients. The number of cases that I am incredibly frustrated by the outcome of are numerous. I mean, so many. It's one of the terrible things about working in juvenile law is you really have to be prepared to have your heart broken over and over again a lot of the time. And It's part of the work. And it means that there always will be people who are upset and who feel like the system is not working, is not supporting them, is not coming up with the right outcomes. Frankly, the fact that when you go back, and I know we do need to do evaluations, and that is a technological problem, and we're going to be back on that within the next year or so. But when you go back and look at our evaluations, and in particular the judicial evaluations, because I think judges are not necessarily always neutral, but that's the most neutral party in the room to evaluate the performance of everybody in the room. And when you look at how judges evaluate the performance of our CHIMS attorneys, they give us pretty high marks, not perfect marks. And we use that for training. We go through those evaluations, and anything that they talk about, we train on. And that's actually, I want to go back to that also. That was something that Barbara brought up in her question, was just the statement that there's not consistent training. And I just wanted to be clear about that, because I think that there was definitely a lack of clarity there. Our training is required for everybody who is a staff attorney or has a juvenile contract. They are required to engage in all of our juvenile training that we do every year, and they can lose their contract, and people have lost their contract for failing to engage in that training. And that training is, we have a required 3-day training in the summer, and then we have a 1-day training, usually in December, sometimes in November, that has to do with where we can get space when. And that's specific to juvenile law and nothing else. Then we have non-required Friday midday trainings that happen twice a month. Some of those are juvenile, some of those are criminal. Those are not required because we have people who are in court during those times. We can't actually require people to be at a training at noon on a Friday because we have other obligations. But we usually draw for the juvenile ones anywhere between 60 and 80 attorneys online on a Friday, which is the majority of juvenile attorneys in the state. There's about 104 overall. So that's to the extent we're talking about training, that is all mandatory training. The only people who do juvenile law who are not required to do those trainings would be people who are assigned ad hoc by the courts, or people who are hired privately. Everybody else can practice in juvenile court, and it's going to be assigned through our office. That's a requirement, whether you are a contractor or a staff attorney. And just to compare us to other states, if you look next door in New Hampshire they don't require any training for their child welfare attorneys. In fact, I found that out when I was calling them to ask, hey, when are you guys doing your child welfare training? This was several years ago when we were having a little bit of a budget crunch, and I was trying to figure out ways to save money at training. And I figured maybe I can get whoever they're using for their training, come and do training for us, and I'll put the travel bill on New Hampshire. And they said, we've never actually done a training on child welfare law. And since then, we've been inviting New Hampshire child welfare attorneys to our trainings. Massachusetts does have a pretty good system of training, but theirs is actually only available to their staff public defenders, not to their contractors. And like us, like anybody who has a system like this, they've got a lot of contractors and staff people. But the CPCS, the Committee on Public Counsel Services, does training there, great trainings. I've attended some of them and actually done a couple of trainings for the Massachusetts public defenders, but they don't include their contractors. So they have a very kind of differentiated system.
So I'd say we're getting into the weeds a little much, but I understand. Karen has a question, and I think we have to move on and have a little bit of a discussion as well. But Karen.
That was going to be what I was going to ask, is just checking in. I did have another question about, because I think that was part of it. We were trying to decide is this need more work? But one little question I have before that is, because I was trying to look for that PowerPoint. I remember you shared that. I don't know if you submitted it to Nate, but I don't see it on the webpage. And I think okay, I think it could be helpful if we are only looking up and seeing information that is on one side of it. It'd be helpful to have that have that additional information.
I thought I sent that, but
Yeah, I mean, I'm getting the impression that we are going to need to dig into this a little bit more. I guess I have a question for you about the timing. You've talked about the work on Title 4E, and If we're not going to be able to put this committee into place right now, having a report by the end of this year as far as the status of that work on obtaining the Title IV-E. In other words, letting this process play out for the next few months, because again, I don't think this is quite ready for prime time. But making sure we're hearing back from you on that.
Yeah, I can talk about 4E for hours.
Yeah, well,
Anytime you want to talk about.
we just want a short, succinct report.
Into that. I mean, 4E is something that's been a pursuit of mine for 5-6 years now. So that's my.
Yeah, so we'll figure out what else we would need just to kind of hear back from as we're going into the next session. Again, there are a lot of issues I think we need to pursue a little bit further, but I do want to hear from, if we could change to move over to our next witness. And if you could join us, that'd be great. Thank you. Thank you for being here.
Thank you. So Brenda Gooley, I'm the Director of Operations for the Family Services Division of DCF. And I testified to this committee earlier on this bill. So thank you very much for the opportunity to come back here again this afternoon. A few key points I'd like to make. First of all, I would like to state DCF, as I testified to previously, has been and continues to be in support of this bill, including the draft language that is reviewed today and the edits that have been proposed today. When I think about some of the work that's occurred in the state of Vermont since 2018, I do think it's significant that the Justice for Children Task Force came together and contracted with the Center for Courts to create the recommendations to improve the CHINS system here in Vermont, and that the recommendations included increasing FORI drawdown to improve the quality and quantity of child and parent representation in the state of Vermont. To me, it's something that is significant when you look across the nation that the Children's Bureau, which is the Bureau of the Administration for Children and Families that oversees child welfare work across the nation, determined that states would benefit tremendously from additional funds to infuse into that child and parent representation system. So more than anything, this is an opportunity to draw down additional funds in the state of Vermont to invest in our system. And, I think about the work that we've done in Vermont, and I will say there's aspects of work that have occurred that I'm very proud of, and aspects of work that still needs to occur that I am truly humbled by. So when I think about myself in the role of Director of Operations over the past decade, we have dramatically reduced the number of children and youth that have needed to come into DCF custody for their safety by 40%. That's very significant. At the same time, we are still ranked 7th in the nation in terms of per capita custody entrance rate. So we know that there is work that needs to be done to ensure that children can remain safely in their homes. FORI drawdown for quality parent and child representation can include pre-CHINS petition representation for children and youth who are candidates for foster care, right? So that's an expansion of our existing system. And that's an opportunity that exists that we have the potential to tap. FORI funds are child welfare funds. They are funds that are earmarked very specifically to go through the child welfare agency, the statutory child protection agency of the state, to provide those services. They pay for Family Services Division staff salaries, training, foster care, very wide range of child welfare services. And we have the opportunity for those funds to also go towards quality child and parent representation. To me, that's really what this is about, is an opportunity for interagency collaboration to see how we can best draw those funds down and maximize the services for the vulnerable families of Vermont. So I am very pleased that I was able to participate in a meeting that Marshall and team put together a couple weeks ago to learn about the agency that the Office of Defender General is intended to contract with to be able to draw those 4E funds down. Fantastic. 100% in support of that. We have some hurdles to clear, I think, to be able to figure out exactly how that happens. But it's work that I think can and will happen and is incredibly valuable for the state of Vermont to be engaged in. I think that that's a beginning. And I think, you know, we may start out being able to draw down a couple $100,000 more in federal funding in a particular area that I think probably could grow over time. And so, you know, to me, this is where we get to the point where, you know, if you want to go fast, go alone. If you want to go far, go together. So, you know, when I speak of, you know, really wanting to approach this with humility, it's recognizing the opportunity before us to engage with our advocates and to elevate the voices of people with lived experience in what they are sharing with us is their experience. Because at the center of all of this is that child or youth who is at risk of coming into DCF custody or has come into DCF custody, and the parents of those children or youth, and their constitutional liberties have been compromised. And we are receiving feedback from them of their experience that the CHINS process is understandably incredibly intimidating, and they are not always understanding what's happening. I think the model that the Office of Defender General is using of having family support workers is incredible. It's a great model. The interagency model that we've looked at of what's happened in New York City and other areas across the nation, fantastic. I think all of the ideas that Marshall just listed that could potentially grow in Vermont in the time ahead would be incredible for Vermont. I do not think state government can do that work in isolation. I think interagency collaboration is not the same thing as oversight. Interagency collaboration is about slowing down enough to bring people together and bring people along. And that's what this bill does. This bill, in a very simple, clear manner, lays out, we should come together. We should look at what we're doing and talk about it and talk about the potential for growth, the opportunities that exist. I don't think it needs any additional consideration. I think it's sound. I think it could be launched and people could come together and do good work. So that's really my overarching point is I just would hate to see us get bogged down in lots of little things and therefore lose sight of the big picture, which is we have the opportunity to come together and do good work.
Typically a CHINS hearing is closed hearing, correct?
Correct.
And in that room, who's in that room?
So we have the judge, the state's attorney, DCF, who actually is their own party in that, guardian ad litem, child's attorney, parents, child or youth, more typically if they're a little bit older. So the parties, all of the parties to the proceedings, there could be an additional individual in the courtroom, for example, a foster parent, or a support person, but typically it's only under certain circumstances, and typically the judge would need to be asking who else is in the room and then approving that proceeding.
And then a TPR, would there be much difference?
In a TPR, it would also then include the Assistant Attorney General. So for Vermont DCF, when we have filed a termination of parental rights petition, that is actually filed by our Assistant Attorneys General, and then they enter an appearance as a party to the proceeding once that petition is filed.
So it's safe to say that these rooms are pretty well stacked on everybody's behalf as far as advocates for most of the sides involved.
Stacked in terms of legal representation for parties, it certainly.
Well, both legal and just in best interest.
Right, so the best interests of the child typically, so DCF would be speaking to, from their lens, best interests of the child, and then the guardian ad litem would also be speaking to the best interests of the child.
As well as the child's interest.
Child's attorney would typically be speaking directly to the child's wishes, which could be the same as or could be different from what someone considers to be the best interests of the child.
So I think we'll certainly have to have a little more discussion here as well. But the question, as far as the 4E funds, what else would they be used for beyond what is in the purview of the Defender General? I mean, if the Defender General has a system that maybe by the end of the year, they're going to be getting some of this money in, what are we missing beyond that? Other opportunities for those funds?
So for example, pre-petition, there could be an individual who is representing a child or youth who is a candidate for foster care, meaning that child or youth is at risk of coming into DCF custody. And there could be representation there.
That would be Defender General again, or?
Could be, doesn't have to be.
Right.
And so pre-petition is an example of an area where Vermont doesn't necessarily have a structure for pre-petition representation. There's a lot of private representation pre-petition, for example, but not necessarily a structure for representation pre-petition. 4E funds are available, could be drawn down for that type of representation.
And I understood from Marshall that that was one of the areas that they could be looking to do. So again, I'm trying to balance the work that's ongoing right now with definitely we need more input. And I mean, well, the system needs more input. What's going on with this, the representation seems to need more input. But we also as a committee, I think, need to understand this a little bit more. We're kind of running out of time. I mean, I'm not sure. It sounds like you have at least been working with the Defender General's office as far as the 4E. Why can't, I guess maybe this is a question to Marshall and you'll have to answer right now. Why can't that in the interim, in addition to asking for a report, which we will have to figure out by the end of the year to see where we are, that you can't be working or reaching out to these entities that are listed in here for input on the work that you're doing?
Because the work that we're doing is not decision-making work.
Right.
What we've been told is essentially that if you want 4E money, you have to have these three priorities, because that's what the feds are approving, because they're approving 4E money for recruitment, retention, and training, for pre-petition representation, for interdisciplinary representation. So that's basically, we're told, if you want that 4E money, that's how you have to spend it, because the feds get the approval of how you choose to spend it. And those are the three priorities that they've been approving. So our intention was to follow that roadmap. And we've been interested in pre-petition representation for a while, and even briefly supported. We had one attorney doing a little bit of pre-petition representation with a grant that she got from, I believe, the Vermont Bar Foundation, and we supported that. We couldn't do it ourselves because we don't have statutory authority to do it. That's something that we would need a statutory change to. But pre-petition representation is certainly part of this on the table. And we expected to, I mean, we went into this thinking that there'd be a lot of decisions to be made about how do you actually spend the 4E money. And what we were told by the experts is, don't get too excited. You're not going to get that many decisions to make, because the feds kind of have three priorities that they've been approving everywhere. And you got to stick to that if you want to get federal approval.
So I guess another just follow, I mean, is it possible to keep the entities kind of in the loop as far as where that is going as well? So there's some transparency as much as it can be to see the progress. Because again, I would like to get this working group together, but I also.
We're in the phase that we're in right now is very sensitive because we are negotiating a contract. And so we're certainly not taking anybody's input while we're negotiating a contract. That's the kind of thing, you know, if we were a public board, that would be an executive session. It's just the nature of contract negotiations. Once we have a contract signed, we're going to be telling the world about what we are doing.
And I'll just add, I mean, TCF is committed to continuing to work with Office of Defender General to move the work with that agency forward, to develop the MOU. There's no reason why we can't do this, regardless of whether this bill goes forward or not. I don't see this bill as prohibiting that work going forward. I don't see it as slowing it down either. I see it as this work is happening. Hopefully that works out. Concurrent to that, we have the opportunity to engage at the interagency level in this wider work of improving the quality and quantity of child and parent representation, including pre-petition in the state of Vermont, and engaging advocates and voices of lived experience in that work and in that process. So I see it as a win-win.
I see you had a question. I mean, I guess I don't know who's my question's for. I think it's actually for Marshall. Do you mind if I ask a question?
Yeah, go. Yeah.
If we were to move forward with this, what is like your biggest fear that could, when we finish the question,
Yeah.
that could come from on the other end of this, right? Like, because, you know, at the end of the day, I think your point on having the sole authority here is well taken if it's true. And I take that seriously and I'm thinking a lot about that. But like everybody involved here, it's like, has been testified to, like those rooms are full of people who are all working towards a common goal, hopefully, which is a just resolution to horrible situations, right? And so like, if what this is trying to do beyond the money thing, and the money thing is only part of it, beyond the money thing, just trying to find the best way to have everybody working towards that goal in the best possible way for like Vermont kids and for Vermont parents. What's the fear? Like what's at that other end?
So I mean, I'll name a few fears. And I didn't mention this because I didn't want to. I mean, this is the awkwardness of it. Is one of my fears is that if this bill passes, that the organization that we were working with will not want to contract with us because they will see that the way this works is they take a lot of upfront risk. They put a lot of upfront work into the process, and then the payoff for them is down the line because they collect percentage of what we are able to draw down from the federal government. So their job upfront is to put all of the compliance and reporting and documentation steps into place, make it all auditable, make it also survive federal AHS audits as well as state audits. And then, only then, once we start collecting money, do they start to recoup that. So my concern just about bill in general is if they see that suddenly there's a lot more mixed up in the Title 40 process than what they had discussed before, which was just a contract with our office and interaction with Department for Children and Families, that they might not want to engage, not want to contract with us because to them, they're risking their upfront investment. And it looks from this bill as if we're giving a lot of other people sort of some input into how should we be doing this for anything? Should we be doing this with this organization? Should we be doing it with another organization? There's other organizations that do similar work. We just have one that we've been working with that we're very comfortable with. There's a lot that could happen that could disrupt that. So that's my biggest.
Okay, so the contract falls through.
Because literally this morning I was sitting there reviewing the contract and then I'm looking at this bill being like, oh my God, what are they going to think when they see that? My other fears are fears that go along with a lack of independence, with being we exist in a world where we all have very clearly defined roles. Prosecutors, in a Chin's case, have a clearly defined role. They represent the state of Vermont. AAGs have a clearly defined role. They represent the Department for Children and Families. GALs have a very defined role. They represent the expressed interest or the best interest of the child. When it gets into saying we're going to have people who are not defense attorneys get together and start to redefine the role of the defense attorney, to me, that's really striking at the heart of the sort of separation of powers within the judiciary that we have. Where we have independence, and that's what makes us good at what we do. It's what makes prosecutors good at what they do. I mean, if we had a lot of input into how prosecutors did their job, I bet we would win more often and prosecutors would lose more often. It's just the nature of the business. I think that it is important to keep the representation of children and parents and decisions about representation of children and parents to be made by people who have an interest in the representation of children and parents. And that's why, you know, as I said, we don't see a lot of proposed amendments. Like, we don't see bills to sort of have a bunch of people get together and talk about what should the judiciary, what should judges be doing, or what should prosecutors be doing. We have other checks and balances for that, just as we have other checks and balances for our system. You know, if the Defender General's system is not doing well, we have the governor waits for the Defender General and can choose not to every 4 years, and the Senate can choose not to confirm it. And just as judges are subject to retention, prosecutors are subject to election. And other than that, we operate with independence, and that independence is important. And having one entity lose independence while the others maintain independence, I'm not sure what that would affect, but I don't really want to find out. I don't want to be the one non-independent operator in the courtroom and try to figure out how much of a disadvantage or advantage does that put me at.
And you sort of see that there's a potential that there could be legislation proposed on the other end of this task force that would take away your independence. Is that what you're saying?
I think that I'm not sure what the purpose of the task force would be if it wasn't to, I'm not sure what the purpose of the task force is. That
Subsection A.
I have read that, but I don't understand what the purpose is, honestly.
Okay, no, that's helpful. Thank you.
So we'll have some discussion on this after the floor tomorrow, just to let us all kind of think about it between now and then. But I do have two things I still want to get done today. So thank you, witnesses. Both should not be shouldn't take very long. One should be actually quite short. And H86, I'll take a motion to find H86 sections that we looked at, which were sections 1, which we actually suggested to folks. Section 2. And I think section 3 are the ones that we kind of dealt with and have had some of the, see, if I'm missing one section, so I'm get that on the record. Bear with me. And section 4. 1, 2, and 4 are the ones that we looked at. Yes.
So moved.
Thank you. So moved. Is there a second?
Second.
This is a straw poll, and I'll catch everybody else's vote because it's a little less formal. All those in favor of finding that favorable, please raise your hand. I've got 4 so far. Unfavorable, please raise your hand. You are 4 to 4.
And I guess, right?
Okay, well, you go with your people. So 4 for the moment. I'll get a hold of Bert and Ian and Angela. So I anticipate it will be 6-5. The other thing is, could we, so we have on 109.
Yeah.
Can you get,
Miss the
can
salt.
you see if Miss get online and share the screen with Eric?
Still raise your hand.
All day for it.
Yeah.
Oh, no, I missed it. It's all right.
Did you, are you?
I can go up. I can be as a, what was the final tally?
It's 4-4 so far, and finding it favorable.
I will vote in favor of the salt bill. So
Favorable. It's what 5 votes so far. I anticipate it will, by the end of the day, it'll be scored by.
is that how straw polls work?
Well, straw polls, it's a little less formal. I can get the vote from the other side. So I just want, so we have I want to just get our input on one section and then we'll have Eric walk through the other parts because I want, because this section has to go back to corrections. And so I want to make sure that we're on board with the changes that we're making to the sentencing reconsideration working group. Before I have,
You want me to get in the chair? It's my section.
yeah, but do you have the language?
Yeah.
Oh, well, that'd be fine.
New language?
New language, the language
No,
that
no.
Eric has just sent and hopefully will be
Spoke too soon.
yeah, no, we had this is changes that we talked about yesterday that let's see. Let me just is Eric trying to get on?
I do not see them. I sent an email and I have copies that were sent to you. So be on the front lawn.
We have to do this now.
Hey, Eric Martin, any chance you can jump on Zoom and just walk through the section 36, the sentencing reconsideration one, not all the other stuff. I'll have you in tomorrow sometime for the rest. But I just want to go through that because I need to get it over the corrections.
We're in S19.
The sentencing reconsideration working group report.
There's new language where
I think it's still section 36.
Not voting on it, we are, and just review it, isn't it?
That's where we added the network and so we added conciliation parts and we changed the languages.
Where did the language come from, Ben?
Initially it came from,
The modified language that we're considering right now.
my
Yesterday.
understanding is our input drafted by Eric. Eric to review it. And then.
Yeah, and I think I'll just have you get on and share the screen and show us the language that you have. For now, because we'll go over it more in depth tomorrow. Just I want to get an initial impression from folks before spending this.
Second look.
Yeah, it's longer than.
It's all your fault.
I'll tell you.
No,
Yeah, not right, yeah, not,
that experience.
yeah, at some point, but it's more important just. Yeah, sure, yeah, go ahead. Yeah, go ahead. That'd be fine too. Oh, yeah, go ahead and send it. And if you can get on and just.
Don't do that so much.
It's just that last section. All right,
Yes. At least that's my understanding.
all right, thanks a lot. All right, bye. All right, Nate will be. You'll be getting on momentarily.
They will.
No, I'm just saying.
Eric.
Yeah, sorry, Eric.
And right here, that probably. There's the pages. If you're on. I can relate to that. But I get over it fast.
Wow.
Nice. Okay, I'll be very careful. I never think the Fed is substantial.
This is fun.
It's time for the meditation.
I'm almost voted against the assault bill because of the de-icing issue.
I was gonna say, I was shocked by your vote.
Yeah.
Well, you like what?
That they wouldn't hyphenate de-icing, they kept it all one word. That almost lost it from here right there.
You almost lost it over something that small.
I'm taking a,
Boy, that's a fine work for your constituent. Should be really proud of yourself tonight.
it's taking a chakra out of your book.
Oh,
Do as I say, do as I do.
You got there.
Therein lies the dilemma.
all right.
I'm making the code, so I'm gonna go run, get copies.
Okay.
Getting copies?
It sounded like copies.
Did you get the latest? Which draft did you send? You need to make sure.
The corrections form.
Just the corrections, just
Yeah,
that
just
one
the
page.
corrections.
Okay, yeah,
Yeah.
but yeah, and that's, we're probably not gonna look at that right now. It's fine. Hello, Eric.
Hello.
All right, if you could just share your screen and just look at the sentencing reconsideration working group component and run through the changes on there, and then we can get it to corrections if we don't have any further changes.
Sounds good. Just making sure, Nate, did you get the new version I just sent you a few moments ago?
He's not in here right now. He's run off to get the copies of the corrections changes. But that's not to this section, so we're not going to deal with those until tomorrow. So I just want to focus on that one section for now.
Gotcha. So, so since he doesn't have it, I'm on my iPad and I can't share the screen. I use the document that he would have posted. Since it's not posted, I can't do that. So, I can log out real quick and I'll log in on my desktop.
Wait a second. Maybe
He found his way back.
All right.
I can also.
This is amazing.
if you could post what Eric just emailed you, the document, then he can share the screen. Then you're able to share the screen? Is that what you said?
Right.
Okay. All right.
Ben can't do it.
Technology.
Okay, so Eric, I'm here. I can pull it up off the DM and share my screen. You just tell me how to scroll.
Whatever's easier and quicker, it doesn't matter to me.
I'm just happy that this is all gonna be on YouTube forever.
It takes a minute for me to post a document
Yeah.
and make it correct.
Ben do
That
it.
way the.
We try to work together.
Oh, we try.
We do. This is very fun. So if we can let Ben jump on, we'll try two different approaches, whatever is quickest.
Contact.
Be the same.
So now.
For me, or for me, to you.
You guys do.
Yeah.
Does it smell like a locker room again?
We are a lot.
You're gonna love this plan, but like you're just saying.
This is amazing. Oh my god.
Right now, all right, well, it's
Literally as I was logging.
Do you, does charger work?
It's probably not faster.
Yeah, right. Wow, it's amazing.
So we're talking about the sentencing reconsideration working group, that one?
yes, correct. I
Okay,
think it,
where are we at? What, as far as,
well, we're, I think it's getting posted, at the moment, but
I
it does
posted the one
take,
that I just received.
it does take a moment sometimes to, actually get up there.
The battery's running out of power. Yeah, I was about to log on and share it. My computer just died. So my apologies, Eric.
no worries, good timing.
Yeah. Seriously, you can't make this up.
I remember, in past years, we've like, had something posted we're waiting for and somehow where it bounces around in the building or what. It sometimes takes a bit.
All right, I see it now.
It's up, I see it.
All right.
Okay, so we're bringing this up on our
Why'd you have to clean that up?
All right, so. There it is. Look at that.
Very nice.
4.1. folks can actually see it as well if they want to follow on their computer.
Sounds involved, yeah.
You've got big fingers. It's called foreshortening. I guess it's 30, it's actually section 37 now, okay.
Yes, section 37.
Okay.
Page 33, it starts. Right?
36.
Are you seeing my screen by any chance?
It's saying something, you are sharing your screen. Oh, there it
Oh, yeah,
is.
we're seeing your desktop. Yep, there we go.
There it is.
All right, you can see it?
Yeah.
Excellent. All right, so yes, it's section 37 now in the new version, which is 4.1, which is today, earlier this afternoon. And as Representative Lalonde, or sorry, I was getting started. Are you ready to start?
Yes.
Okay. So yes, Eric Fitzpatrick with the Office of Legislative Counsel talking about some of the new language in the updated miscellaneous judiciary procedure bill. In particular, now new section 37, the sentencing reconsideration working group. You may recall, this is a working group that's looking at the criminal sentencing review process, proposing any changes to current law or practice. The changes, the first couple really involve membership of the working group itself, as well as the creation. Remember, we added some consultation entities. So firstly, with respect to the membership, two new additions you see are 5 and 6, executive director of the network and the executive director of racial equity, or designee in either case. So those are the two new members of the working group. And then newly added here are some people and entities to consult with. So you remember you've had that in some other working groups / study groups that are kicking around in the miscellaneous bill, the consultation piece, I mean. So that's here now. And there's 3 people to consult with. Drop LWOP New England. You may recall that that entity, or the executive director of that entity, which is, I believe, Drop Life Without Parole is what that stands for. In the previous draft, that person had been on the working group. So the proposal here is to shift them from the working group to the list of consulted parties and add to the list of consultees the Racial Disparities in the Criminal and Juvenile Justice System Advisory Panel and the ACLU of Vermont. So you got 3 new parties to consult with.
And before you go on that, just a couple comments for the committee. I did get an email from Jordan Soder. I just probably really murdered his name, from the ACLU Policy Association, asking to be on the working group, but I thought it was more appropriate for that entity be part of consultation. Also, I had a separate phone call with Commissioner Morrison. I know that Zach asked about that. I asked her if she wanted to be on this group. She said she'd be willing, but doesn't see a need. It's not asking to be put on the group. So we can decide whether to put, you can check with her as well. But she was not eager to be put on the group because she's on 100 of them, or they're on 100 of them. I don't see a need to have them on the group because this all happens after conviction. And I think that she agreed with that. But so go ahead, Eric, with the rest.
Yeah, sure. So talking about the powers and duties now, subsection C, subdivision 1, line 11. You may remember this was something that Judge Zone suggested that since we don't have sentencing guidelines, practices would be a better term there. Subdivision 3 is actually a bit of a combination of prior subdivision 4. Remember that you had separate resources and procedures of the judiciary and DOC last time. So this just folds it all into one phrase. So it'd be the resources and procedures of the judiciary, DOC, the Defender General and the Department of State's Attorneys and Sheriffs. And then the other question, remember the committee had been talking about how to phrase subdivision 5. There had been, I think, some discussion with the Defender General's office in particular, and I think the court weighed in as well to try and frame that in a way that the committee was looking for. So the proposed language here is that part of the duties, again, is that the working group is looking at the manner in which a Vermont second look sentencing review process could operate and how that process could relate with other post-conviction remedies currently available.
So on that one, Eric, I think it should, unless you have a good reason not to, I like the language better if it was the manner in which a Vermont sentence reconsideration process, because I think that broadens it beyond second look. Then essentially you have the same language. So that the manner in which a Vermont sentence reconsideration process could operate and how that process could relate with other post-conviction remedies currently available is what I would suggest. I thought I sent you the language, but it's very possible I didn't hit send on the email that I.
No, you did. You did send it. I thought I pasted it incorrectly, but I must not have. So
okay.
The first part is you're saying the manner in which a Vermont sentence or sentencing review process.
Yeah, I think what you need to do is just strike second look.
Okay.
From your language right there. Yeah, that's all. Just sentencing review. Or no, I'm sorry, sentence reconsideration process. So I'd strike second look sentencing review and add sentence reconsideration process. So when you get back to that. So
sound good, will do.
Okay, thanks.
Yeah.
Yeah.
And maybe put in a post-conviction sentencing review process.
Makes sense. Does that make sense to you, Eric and Ben? Post-conviction?
Yeah, I think
Or is it?
right now, the second look process wouldn't be currently available because it's not on the book, so.
Yeah, but I would think that a sentence reconsideration process, that means post-conviction, doesn't it?
So right now, you can file within 90 days to have a sentence basically reconsidered.
Yeah, right.
So we're not talking about that. We're talking about something like further down the line, right?
Yeah, but I think that this captures.
That captures what I
thought. I think.
Yeah.
I think.
So no further changes there.
Yeah, no, I think that.
Overruled.
Yes, Ian.
So I have written in my notes from, I think it was Rebecca yesterday. So RDAP, that's number 2, racial disparities in criminal juvenile justice system advisory panel.
Yes, in the consultation.
Another one that she was talking about was the sentencing commission.
Yeah, that's a whole other kettle of fish. I mean, the other option is that we could just be sending this whole thing to the sentencing commission, but we decided not to. What's that?
Yeah. It's boomerang there
Well,
already,
they
yeah.
kind of have seen it once.
Second look.
So this is coming from someone who doesn't really know what they're talking about. That's not somebody that we should also have as
No,
a
because
consultant.
it's some of the same individuals plus additional.
Okay.
people. So,
And then my final one is there a possibility that we could write out whatever LWOP stands for?
oh,
It's technically not their name. They abbreviate it.
They're like DRM.
Yes.
Interesting.
well, as long as we know who they are, I suppose, if that's what they go by.
All right. So I guess none of my things. None of my things stuck. All right. Well, I'm gonna stop talking now.
Thanks, Ian.
Yeah, appreciate it. Appreciate you guys.
Aim for effort, really. So I mean, no, I guess,
Gallivan.
so really there is nothing for LWAP? That's it?
That's it.
All right, okay.
On their masthead and everything.
Okay.
Yeah.
Hi, Ayush.
All right, check into that, Ian.
I'm gonna take a
All right, proceeding, Eric, thank you.
Yeah, sure.
I guess that might be it, except for deleting D, right?
Yep, that's it.
All right, so we'll go through the rest of the stuff. Any huge issues with that language so that we can say, yeah, it looks like we haven't voted on it, but we're generally fine. I'm not seeing anybody saying, I hate that or whatever.
Yes, if you want.
All right, Eric, so if you haven't already, well, actually, if you could send that latest language with that correction that we just made for that one section, if you could send that section to House Corrections, I'd appreciate it.
Okay.
Just that section?
Yeah, just section 37
Okay, sounds good. Will do.
with the language we just talked about. I appreciate it. Thank you, Eric.
Hey, no problem.
Thank you.
Yeah, thank you.
And so we'll find some time tomorrow to schedule the walkthrough of the rest of this, because there are a couple changes that were recommended by the House Corrections and Institutions on a couple of the divisions that they are sharing with us. And then there's a couple other things that we have changed since the last version, but we'll plan hopefully tomorrow after the floor, Eric. Hopefully you have some availability to do this final walkthrough, and then we'll have it on for a vote on Friday.
At what time's the floor?
Floor's at 1 and it shouldn't be too long.
Yeah, sounds good. That works for me.
Okay, all right. Thanks a lot, Eric.
Great, thank you. We'll see you guys tomorrow.
So I guess the one thing that we still have as well is figuring out, I mean, I do want to have a discussion further on 193 tomorrow, but at a minimum, having a report requirement by Defender General by like the end of the year. You don't want that? I know you want the whole thing in there. I don't see how we can put this into the miscellaneous bill like by the end of this week.
Right. Can't we do a straw poll?
We can do a straw poll. I mean, our.
The DCF was pretty clear that they thought it was ready, and they're as equally important in this process.
Yeah, no, the witness definitely said that, and then went on to explain how they're working with the Defender General on getting this 4E, and then, and I pressed as far as, well, what are the funds that are not covered by what the Defender General is after, and it sounds very much that they have this petition that they're looking for as well. I mean.
And
Okay, I'll, if I may,
Yeah, go ahead, please.
I know we're live, and so I'm restraining myself,
Need to be live.
okay?
Yeah, no, I know.
And I'm saying that out loud, okay? Because I know people who've been affected by our inaction. And our inaction is not acceptable anymore. Okay?
Right.
I mean, to have somebody take your children away, and it could have been done differently, better, or not at all, is unacceptable. And this speaks directly to it. 98% of the people involved in the process say, let's fix it. And we have a very small subset that says, yeah, maybe not. No way. I'm sorry. I am just, that's where I'm at.
I am.
You know, I've heard the stories. I've been party to one of those. No. Yeah.
No,
I'm sorry to be so reticent about it, but 50 years of dealing with this crap and having people not deal with it, I'm done. I mean, come on. We can't keep kicking cans down the road. Kids' lives are at stake. let alone us as the adults, dealing with our own crap in it. But the kids are affected.
It's not kicking the can in this case, it's keeping the can when we need to be making changes so that kids and families aren't going to suffer.
Right, so, are you concerned that, this concept that it may upset the ability to get this contract signed, that is going to be the next step for getting 4E or
I
no?
cannot believe that that somebody who is going to make money is going to not move ahead with the contract. And frankly, if this contractor has worked with different states, they probably have worked with states that are more collaborative.
I just want to direct the committee to the language of the bill, which I don't have in front of me since my computer died. But for the record, again, Ben Novogrowski from the Office of Legislative Counsel, to address the concerns that were raised by the Defender General's office. There's no prohibition that they are hindered in any way from pursuing the initiatives that they're pursuing with this contractor. This also isn't substantive law, for lack of a better term. This is a task force. Maybe with the extension of its longevity, it turns into a working group. I don't know. But the end result of this task force is to issue a report with legislative recommendations and also propose legislation. I don't, and obviously the Defender General's office is privy to information that I am not and that the committee is not. But I don't see how a report and proposed legislation can upend a contract. But if there's a legal reason why, I'd be happy to analyze that and present it for the committee. Additionally, while this also doesn't, as I said, it doesn't prohibit the Defender General from pursuing their initiatives. There's also nothing to say that it excludes anything that they do on their own from being incorporated in the proposal that's submitted by the task force. And so if they do a lot of great work with the Title IV-E funds, and that is specifically contemplated as one of the topics to explore by the committee, it's reasonable to say that actually assists the committee in its work, or the task force in its work. But again, if there's other information out there to show why it somehow hinders it, that's something as legislative counsel, I would be happy to analyze for the committee. But without that, it's hard to see why. And so again, the way that this was phrased and crafted in this version was, and when I suggested to the Defender General is that the need for it is embodied in subsection A, that there is created a task force to study the need and viability of an improved legal representation system for children and families who are involved in it in various proceedings. So study the need for it, which the different data figures that have been testified to can be analyzed within that group setting. And then if a need is identified, then you move on to the next step of the viability of that system, which might be provided by the Title IV-E funds or other funding that's also explored in this task force. And it's not just limited to, the Defender General is actually not mentioned at all in this, except for as one of the members of the committee. But subdivision C4 talks about, studying the topic of using an interdisciplinary model of representation with certain measures of performance for attorneys, social workers, and other child and family representatives. So it is not just targeted at attorneys. And definitely, at least in the language here, the Defender General specifically. So I'm putting this forward to the committee to remind them that this is the language of the actual bill.
Right.
And nothing in it prohibits any entity that's involved in this from pursuing their own initiative.
Excuse my passion about this.
No, it's justified.
But when I think about this group whatever we choose to call it, for whatever purpose it's involved in. What it shows, if I'm a provider and I just had unlimited resources and somebody said, oh, I'm one entity and I'm going to deal with this. And I wrote a really good proposal. And on the other end, as Ben was just saying, there's almost the whole state coming together from varied parts of the process that are affected. Some people could look at it and go, why would DCF want to look at itself and do more work? And why would this group want to do? Well, they do. So that must, if I'm a provider, I'd go, whoa, that's collaboration. That's the opportunity to grow this thing the right way versus one group saying, yeah, I got this, and
Stop
that's
meddling,
not
right? Stop meddling.
to say that anybody is, trying to do it on their own. But if anything, this is a consolidated group of Vermonters saying, we want to fix this. And I think that to anybody looking at it,
Yes.
says that.
We're having a discussion now.
Yes, yeah, right.
On what you have to say and what I heard. I asked a question earlier about who's in the room. Because I knew who was in the room and I wanted everybody to hear who was in the room when things like that happen. And I've sat through, I can't even tell you how many TTRs and Chins cases. And yeah, I think Marshall is somewhat correct and someone's always upset when at the end of these things, because either somebody's on the losing side, but I'm amazed at how many people are in there trying to do the right thing. But I think maybe they need to sit down, I don't know, and evaluate maybe what's going on, just to reevaluate what's going on. It may not be they're doing anything wrong there. It may be a demographic or something that's happening somewhere else that's causing this to happen in the court. These TPRs. That makes sense. I mean, like, do we have more incarcerated people that have children? Or that they know of, that's just certain about Vermont. Maybe we just know more about the people we're dealing with. I've never seen anything really happen in one of these that I was surprised about and disappointed. Definitely some people got upset.
But sometimes attorneys are not, they're meeting their clients that day. They have so many cases, they're not necessarily giving them the attention that they need, and people don't feel satisfied with their representation.
I see that more on the criminal side than I do on like a juvenile side. Juvenile side, I think there's just so much more preparation.
So how about this as far as a couple things then? We put the changes in here that we talked about today, get rid of potential, strike the 6 meetings, change February 15th to May 15th. We'll have a straw poll tomorrow afternoon as far as whether to proceed with this, or if are there other additional testimony that we can try to schedule?
Child advocate, I heard from some already, right?
Yeah, what do you think, Ian?
Well, I really appreciate, Coach, I appreciate your points. And I think the only thing that I'm feeling a little uncomfortable about is just that the disparity in like the different like positions that parties are taking on, like what the reality on the ground is. Like, I feel like it's like one of the first times I've had the experience in the legislature so far where it's been so different. And I guess like that's the only thing. I don't know if we have time, and I can think of more about this tonight and stuff and talk to people, but like, yeah, I'd love to understand why we're hearing just such different things. It just doesn't
Mr. Chair.
Yeah.
I could, well, I don't know. She probably. Very short.
Yeah, go ahead. Yeah, go ahead.
Can I drop in one thought? It's just
Yeah,
one
sure,
thing
sure,
that
sure,
I
please.
think I'm struck by that as well, and to me, that's why we need this.
It's a fair point. Yeah, maybe that's the answer alone, right? Yeah. 'Cause I feel like for most other things that we've talked about so far this session, like people are disagreeing about things, but often there's at least some commonality around like what's
Right, this is like.
Yeah, this is like-
The universe.
yeah, we're like hearing completely different stories.
Yeah.
So
Just Larry Christ, again, thank you very much for the Vermont Parent Representation Center. Just a couple of key pieces. I think that Ben's presentation was on the money. And I first raised this issue with the legislature, exactly this issue of representation in 2018. Marshall was called in after me, and he gave exactly the presentation in 2018 that he gave today. That he had never heard, and then he said he had never gotten a complaint, ever. I get complaints every week, and I review those complaints, and I work with his attorneys. I work with the social workers. I get calls from them saying, I have this case, I don't know what to do with it. And I work with them to figure out, okay, here's what you can do. Here's what the social workers have to do. My background is as a lawyer and a licensed social worker. I've done this for almost my whole career. The reality is, contrary to what was said in this hearing, I initiated a DCF, child advocate, et cetera, voices, and Defender General meeting. Only one entity didn't show up. I then followed up, no response. I followed up again, no response. I had my board chair contact Marshall. My board chair is the former Defender General, no response. You can't make somebody come to meetings. Everybody else came to the meetings. The language that you've seen is the product of DCF, the voices, BPRC, and the child advocate. This isn't my writing. It's a collective effort each time that has come back to the same point. We've agreed at every point to water the language down to try to get the Defender General's office to say, yeah, we want to participate in the process. There are some things that Marshall said that are absolutely true. They do follow the ABA rules in court. But they don't require their attorneys to meet with their clients. There's no requirement that they do that. There's no follow-up that they do that. Typically, clients meet their attorney in court, just before court, and don't meet with them again. And in the end, as they get close to a merits decision, the kids have been removed for anywhere from 3 months to 6 months to a year by that time because of all the delays. The message to the client is plead to the merits or stipulate to the merits, and you'll get your children back faster. I then ask the people, what do you think stipulation to the merits means? They don't know, because no one explains to them that they're admitting guilt. Consequently, if you look at how many cases go through that actually go the whole process, it is a pittance. It's a lot of plea deals, but the difference in a plea deal is when you're in the criminal side and you plead to something, you know what the sentence is going to be. In this instance, they think they're going to get their kids back. Yet that same plea is then used in a TPR hearing. It's used in a substantiation hearing, and they can't contest it because they admitted in open court that they did something, which they never had evidence that they did. Now, the last piece I'm going to say is this. I had a family 2 weeks ago contact me. 2 sisters. One sister has had her children removed. She was initially charged with one thing. That was changed to medical neglect. To prove medical neglect, you need to show that you didn't take your children to their appointments, that you didn't follow doctor's advice, etc. They contacted me because they said their attorney wouldn't get the medical records for them. Now, this is an attorney who is a large contractor with the Defender General, but in this case, they were paying privately. I said, how much is she charging you? $3,500. You can't pay for the attorney's parking for $3,500 for a case that's going to go to a merits hearing. The standard charge is a $10,000 retainer with the assumption that it will cost you $20,000 if you go through the merits hearing. I said, when's the merits hearing? Well, it was scheduled for last month. Why didn't it happen? Because our attorney wasn't prepared. When's the next merits hearing scheduled for? A month from now. Okay. Has she met with you? No. Has she asked you, has she gotten the medical records? Because that's the key to this. They say we've taken the kids to every appointment. No, she told us we have to get them. I don't know whether this is true or not. So I say, let's set up a meeting with your attorney. The attorney didn't want to have that meeting, but they finally said, we want you to meet with Larry Christ and with us. We had the meeting. The attorney acknowledged that she had not gotten the records. And she said, we'll get the records, and Larry, we'd like you to review them to help with figuring out what the defense should be in this case. I said, great, send them to me. I'll look at them as soon as I get them. I got a message from the sisters 4 days ago. Their attorney right after the meeting said it's our job to get the records. Well, they've already been told by the hospital they can't have the records because their kids are in DCF custody. Therefore, they're not allowed to get the medical records. Only their attorney can. I guarantee you, in 2 weeks, this attorney will go into court with no evidence for a merits hearing. This is someone that they're paying, but this is also someone who handles other cases that I have seen this attorney with when they're paid by the Defender General's office. It's the same behaviors. Now, the last piece I'll say is this. The ABA guidelines that Marshall is talking about aren't the guidelines we're talking about. We're talking about the guidelines to put in to interdisciplinary practices so that the attorney has to demonstrate that they have met with their client outside of court, that they have produced information and evidence, that they have a social worker who has gone and reviewed, is DCF's report correct or not correct? And DCF itself has asked for this because they're not magic, they're not God, they don't get the information right all the time. Now, for those of you there are a few people in the room who know me, who say, Larry, you and DCF, you used to be written on the DCF bathroom walls, for being spawn of the devil. How come you're coming to these things now with them? It's because we're all working toward the same goal. There is nothing wrong with the Defender General's office, except it needs to be managed in a new and better fashion than it is now. I don't know what the Defender General's problem is, but just giving money to any state agency without telling them they have to up their game and having a way of saying that they're going to up the game, don't any of you complain about wasteful state government. Because frankly, that's what we will be doing in this process. Now, I think the Defender General working with a contract company in concert with DCF, that gets us a step ahead. If that, in fact, process is viable and works, but this group can also look at that process. My understanding is the only thing that entity does is just manage the money. That's it. That's what they do, the accounting part, because that's what's key. It has nothing to do with programming. It has nothing to do with how the programs unfold. I just would like to see, along with the thousands of parents, I've probably worked with 4,000 families in the 8-9 years that I've been doing this job. And it's in the ballpark of, usually when I do my annual report, 400 to 700 families a year. Some, it's just a brief consultation. Others, it's months. There are a few I've carried for years now because of this. It's just to make this system work properly so that the public money is spent getting the best service that we can get. So everybody benefits. The kids benefit, parents benefit, DCF benefits, the Defender General's office benefits, because it will then be able to come to a committee like this in the future and show, here's our data. We meet with our clients 100% of the time before going to court, or we only do it 75%. Here's why, and they can explain it. That's all we're asking here. This group isn't going to change how attorneys, practice law. It's not going to change the law itself. It's simply going to put a better system in place so that we can all say we're doing the best we can with the money that we have.
Yes.
And I can't tell you why there is this change, except that sometimes certain managers have been doing things, guilty of it in the past, the same way for so long that they own those programs. And any suggestion those programs aren't working at top flight is a personal. There is nothing personal about this process. It's just how do we fix the system? That's what it's about. Okay, thank you, Laura. Any questions? I'm happy to answer them. I think you probably heard more from me than you want.
So is there anybody else that, one needs to hear from to decide what to do? I'm looking at you, Ian.
Oh, God. I mean, I don't,
Because I am pushing to have 109 out on Friday, but if it's gotta be pushed back a day or two, if there are people that we can bring in to help this one, that's fine.
I mean, the only thing I could think of would be just to roll in here like a bunch of practitioners. And here, like, yeah, that's like, that would be the only way that I would be able to be like, okay, so this is actually what's happening. And I don't think we're gonna be able to do that. So I can just, I'm not trying to hold this all up. I'm just.
Nor would I, but I would also be curious, the judiciary side on, how are these things going down that may be not the best situations in front of the judge? Why aren't they catching? Well, I should be seeing this, I should be seeing that. And I'm not pointing a finger, but I mean, did it get through?
Sure. I think for me, I don't think I need to take, I don't need to hear from anybody else.
I mean, you can get Zone A back again if we want.
Just,
We can get Justice River to close this for us if you want.
if you'd like, I will contact the chief and ask him if he would consider, like just sharing, his vision. Because when we spoke about this at the, actually it was at the inauguration, he came up to me and he said, "Do you think we have a chance of pulling this off?" And I said, "Yes, because it's for the kids." He said, "Great." So what that tells me is he's committed to making sure that his branch does the best job possible. That's why he agreed to take the lead on it. And that's a commitment to change.
So can you go ahead? Yeah, reach out to him, see if he's available in the next few days. And won't be tomorrow morning because we have a joint here, but otherwise we can be flexible.
Yeah.
All right, thank you, everybody. We'll adjourn until tomorrow.